Let me now, to kick off this conference on perpetual conservation easements, introduce my colleague and the principal organizer of today's event, and that's Professor Nancy McLaughlin. Nancy is the Robert W. Swenson Professor of Law here at the S.J. Quinney College of Law, where she teaches trusts and estates, estate planning, federal income tax, and a course on conservation easement. She's an elected member of the American Law Institute, a fellow of the American College of Trust and Estate Counsel, and a professional editor of the American Bar Association's Real Property Trust and Estate Law Journal. She's got numerous professional affiliations, including several with the Land Trust Alliance and other nonprofit organizations involved in the land conservation movement. Nancy's scholarship focuses on conservation easement, tax, and nonprofit governance issues. She's widely published in the area and lectures extensively across the country on these topics. With that, let me turn the conference over to Nancy, who will introduce it in more detail. Thank you again for joining us today.
Thank you, Bob, for that very kind introduction. And welcome, everyone. Thanks to all of you for coming, and thanks to our remote viewers for tuning in this afternoon. We have a great conference planned for you today with a slate of terrific presenters. Our focus this afternoon is on perpetual conservation easements, those that are advertised, as you can see from this slide, as protecting the property they encumber in perpetuity or forever. There's been an extraordinary growth in the use of these easements in the United States over the past 3 decades, as well as many major developments. And the purpose of this conference is to give us a chance to pause for a moment, take stock, look at the history and legal underpinnings of this unique tool, consider the successes as well as the problems that have arisen as a result of its widespread use, and consider proposed reforms and how to deal with the difficult issues associated with the long-term administration of these instruments. To provide background for the panels, I'm going to briefly explain for you the growth in the use of conservation easements and in the number of nonprofit organizations acquiring these easements, typically referred to as land trusts. I'll talk about the various laws that impact the creation and administration of easements. I'll give you a timeline of important developments in this area, and then at the end I'll briefly note what I consider to be the elephant in the room whenever we are talking about perpetual conservation easements. So starting with the extraordinary growth. Based on statistics gathered by the Land Trust Alliance, which is the umbrella organization for the nation's land trusts, there were only 53 state and local land trusts operating in the United States in 1950. And at last count, in 2010, there were 1,699 such land trusts. The growth, as you can see from the slide, has been dramatic until the last 5 to 7 years, when the number of land trusts started to level out. This slide illustrates the similarly dramatic growth in the number of acres encumbered by conservation easements held by these state and local land trusts. As you can see, in 1980, only approximately 128,000 acres were so encumbered, and by 2010, that number had grown to more than 8.8 million acres. This chart also does not include acres encumbered by conservation easements held by national land trusts, like the Nature Conservancy, which in 2010 reported holding easements encumbering over 2.7 million acres. It also doesn't include acres encumbered by conservation easements held by federal, state, and local government entities, which have also been very busy acquiring easements. This slide gives us a more complete picture of the total acres encumbered by easements in the United States. Note that the scale on this graph has changed. The darker green bar along the horizontal axis indicates the growth in the number of acres encumbered by easements held by state and local land trusts, just as we saw on the previous slide. However, an entity known as the National Conservation Easement Database is gathering data on acres encumbered by easements held by all land trusts, including national land trusts, as well as by government entities. As of 2012, as you can see from this slide, NCED had gathered data on conservation easements encumbering just over 18 million acres in the United States, and moreover, it estimates that there are actually 40 million acres currently encumbered by easements. So we are not talking about an insignificant amount of land. Now, turning to the laws that impact the creation and long-term administration of conservation easements. First, we have the federal tax incentives that are available to property owners who donate easements in whole or in part as charitable gifts. The primary federal incentive is the federal charitable income tax deduction under Section 170H, which was enacted in 1980. Although easements were deductible before 1980, Congress imposed substantial new limits on the deduction in 1980 in an attempt to minimize abuses in this area and ensure that the easements would provide benefits to the public sufficient to justify the revenue loss from the deduction. Congress also stated that it intended for this deduction to be limited to conservation easements that permanently protect unique or otherwise significant land areas or structures. In other words, it's not intended to apply broadly to ordinary lands or ordinary structures. To be eligible for the deduction, your conservation easement has to be granted in perpetuity to a government entity or charitable organization exclusively for one or more of the 4 conservation purposes enumerated in the Internal Revenue Code, and the conservation purpose of the easement must be protected in perpetuity. The Treasury regulations interpreting 170H contain numerous additional very detailed requirements, including those listed here on the slide, such as restriction on transfer, no inconsistent use, mortgage subordination, baseline documentation, and at the bottom there, extinguishment and division of proceeds. The extinguishment and division of proceeds requirements were included in the regulations because the Treasury recognized that changed conditions might in some circumstance make the continued use of the protected property for conservation purposes impossible or impractical. The regulations provide that in such a case, the conservation purpose of a tax-deductible easement will nonetheless be treated as protected in perpetuity if that easement is extinguished in a judicial proceeding and the holder is entitled to a share of proceeds to be used to replace lost conservation values. The first panel this afternoon is going to address these federal tax incentives. Next we have, under relevant law, our conservation easement enabling statutes. Land use restrictions held in gross were generally disfavored under the common law because they reduced the marketability of land. Because most conservation easements are held in gross, state conservation easement enabling statutes were necessary to sweep away these common law impediments to the validity of in-gross restrictions. However, states were willing to relax the rules in this context only if the conservation easements are created for conservation purposes that benefit the public and are granted to entities that are organized and operated to benefit the public, and that is generally government entities and charitable organizations. Our second panel this afternoon is going to address the easement enabling statutes. Then we have the federal and state laws pertaining to charities and charitable gifts. As part of the third panel, 2 of the nation's leading experts on nonprofit governance will outline the history of the development of the laws governing charities and charitable assets in the United States. They are going to address a fundamental issue that is relevant to the charitable sector as a whole, and that is who guards the guardians, with the guardians being the charitable organizations and government entities that hold charitable assets worth billions of dollars on behalf of the public. The fourth panel this afternoon is going to focus on the sometimes unknown and sometimes misunderstood role that state attorney general offices play in both regulating and assisting charities. Panel 4 will also provide us with some examples of how some land trusts have been developing productive relationships with their state AG offices. Now, turning to the timeline of developments. It's helpful to see the developments depicted against the backdrop of the growth in the number of acres encumbered by easements. Now, starting on the bottom left-hand side of this slide, you see that in 1980, Section 170H, our federal deduction provision, was enacted. 1 year later, in 1981, the Uniform Law Commission promulgated the Uniform Conservation Easement Act. This gave states a model by which to sweep away those common law impediments to in-gross land use restrictions in this special context. In 1982, the Land Trust Alliance, then known as the Land Trust Exchange, was created. In 1986, the Treasury published final regulations interpreting Section 170H. In 1989, the Alliance distributed the first iteration of the Land Trust Standards and Practices, which are ethical and technical guidelines for the responsible operation of land trusts. In 1997, after lobbying by land trusts, Congress enacted Section 2031C of the Internal Revenue Code, and this provides easement donors with an additional estate tax incentive. In 1999, states began enacting state tax credit programs that provide even more tax benefits to easement donors. Colorado, Virginia, Delaware, and Connecticut were pioneers, and at last count, there were more than 16 such state programs. Well, it all seemed to be going along swimmingly, with an additional 3.6 million acres encumbered by easements held by state and local land trusts from 1998 to 2003. But then, in 2003 and 2004, the Washington Post published a series of articles describing transactions involving wildly exaggerated easement appraisals and property owners who received shocking tax deductions for donating easements that encumber golf course fairways, undevelopable lands, and buildings already subject to local historic preservation restrictions. These articles raised the ire of Congress. The Senate Finance Committee launched an investigation, and it also got the attention of the IRS. In 2004, the IRS issued a notice indicating that it's aware of abuses and it intends to disallow deductions, impose penalties, and revoke the tax-exempt status of nonprofit organizations where appropriate. The IRS also began to substantially increase its audit and litigation activity in this context. In 2005, the Senate Finance Committee, Joint Committee on Taxation, and the Bush administration proposed a variety of reforms in this area. Land Trust Alliance, meanwhile, was working diligently to educate Congress and the IRS regarding the distinction between legitimate and abusive conservation easement donation transactions. In 2006, Congress enacted the Pension Protection Act, which revised the rules relating to facade easements, also revised the rules relating to appraisers, and it increased the accuracy-related penalties in this context. But it also, the Pension Protection Act also temporarily enhanced the incentives available to easement donors. These enhanced incentives, which among other things potentially allow a farmer or rancher to literally wipe out his or her income tax liability for up to a period of 16 years, these have been repeatedly extended, most recently in the fiscal cliff deal. Well, also in 2006, as part of its efforts to respond to reports of abuse, the Land Trust Alliance organized the Land Trust Accreditation Commission, which is an independent program governed by a board of volunteers who verify that a land trust is carrying out specific practices from the Land Trust Standards and Practices. And as of January 2013, the commission reported having accredited 180 land trusts, or a little more than 10% of the just over 1,700 land trusts extant as of 2010. In 2011, the Department of Justice filed a complaint against a nonprofit that was soliciting and accepting facade easement donations, alleging that it was engaged in abusive practices. Although the nonprofit did not admit the allegations in the complaint, this case eventually settled with the court issuing a permanent injunction against the nonprofit, prohibiting it from engaging in the alleged abusive practices and requiring it to pay an independent monitor for 2 years to ensure that it complied with the injunction. In 2012, the Obama administration proposed to eliminate the deduction with regard to easements encumbering golf courses. Moreover, the IRS issued guidance explaining that the extinguishment or swap of tax-deductible easements is permissible only if such actions comply with the Treasury regulations' extinguishment and division of proceeds requirements. Lastly, in 2013, at least so far, Department of Justice filed another complaint, this time against an appraiser who has appraised more than 90 facade easements for purposes of the federal deduction and who allegedly continually and repeatedly used improper appraisal practices to grossly inflate the value of the easements. This case also settled. Again, the appraiser agreed, the appraiser consented to the permanent injunction without admitting the allegations in the complaint, and the permanent injunction bars him and his company from preparing any more appraisals for federal tax purposes. Also in 2013, the Alliance launched its Conservation Defense Insurance Program, which will insure land trusts against the legal costs associated with defending easements from landowners and third-party violations and other challenges. This, of course, is a historic development, provides terrific assistance to land trusts. It does not, however, address the issue of who guards the guardians. Well, meanwhile, as all of this has been occurring, there's also been an extraordinary amount of IRS audit and litigation activity. This chart depicts the case law involving IRS challenges to charitable deductions claimed with respect to easement donations. Because the law governing the deduction has changed over time, this chart organizes the cases based on the date of the donation involved. Of the 60 reported cases that have been handed down, 11 involved donations made before and 49 involved donations made after Section 170H became effective. A full 30 of the 60 cases, as you can see, involved donations that were made from 2000 to 2004, with 24 of those cases involving donations made in 03 and 04 alone, which perhaps not coincidentally are the years that the Washington Post published its articles. There are also, according to the IRS, are approximately 200 additional cases in the litigation pipeline. This slide, which lists the 36 deduction cases handed down since 2005, might give you a little better sense of the enormous expenditure of judicial, administrative, and taxpayer resources in this context. As for the substance of this case law, in slightly more than 1/3 of these cases, 14 of the 36, the IRS attempted to disallow the deduction in its entirety based on the taxpayer's failure to properly substantiate the deduction. Although this is a very efficient silver bullet approach for the IRS when it works, it has met with mixed results in the courts. In 30%, or 11 of these cases, valuation was an issue, and in each of those cases, the court determined that the taxpayer had overstated the value of the easement, often by a significant percentage. 15 of the cases, close to 39%, involved interpretation of the provisions of Section 170H and the Treasury regulations. Some of the requirements interpreted were the conservation purposes test, the extinguishment and proceeds requirement, the mortgage subordination requirement, and the granted in perpetuity requirement. Two of the more recent cases involve what are known as quid pro quo transactions, where the transaction was, or in one case, allegedly, where the transaction was not, and in one case allegedly was not, a deductible charitable gift because the conservation easement was conveyed in exchange for development approvals or some other form of compensation and therefore did not qualify as a gift. Okay, so why is the IRS focusing so much of its audit and litigation attention in this area? Of course, we have our Washington Post articles, but also Section 170H is an expensive deduction provision. This chart indicates the number of easements donated in the years listed and the average value of the deduction generated by the donation. As you can see, these are on average very large six-figure deductions. Moreover, collectively, federal taxpayers are investing billions in these instruments. In just the 6-year period from 03 to 08, there was an estimated revenue loss of $3.6 billion from the Section 170H deduction. Finally, I want to end by briefly noting what I consider to be the elephant in the room whenever we are talking about perpetual conservation easements. It really is astonishing that more than 3 decades, billions of dollars, and an estimated 40 million acres into this, we still don't know, and we are still quite vigorously debating in some circles what it actually means to protect land in perpetuity or forever with a conservation easement. Can these perpetual instruments be modified or terminated to respond to changing conditions, to accommodate the wishes of new landowners, or even to raise cash that the land trust or the government holder can add to its general operating funds, or perhaps use to pursue what it perceives to be better conservation purposes elsewhere? How is the public interest and investment in these easements and the conservation values they are supposed to preserve in perpetuity for future generations protected under the law? And what deference should be accorded to the intent of conservation easement donors, many of whom agreed to make a charitable gift of an easement, often at huge personal economic sacrifice, in part in exchange for the promise of permanent protection of their particular land? There are some who believe that there should be a very high threshold for the termination of perpetual conservation easements, that they should be terminated only through condemnation, or if it can be established to a court that continuing to protect the conservation values of the land has become impossible or impractical due to changed conditions. There are others who argue that perpetual conservation easements are simply private contracts between the owner of the land and the holder of the easement, similar to a right-of-way easement between neighbors. And, of course, as soon as the statute of limitations has run on the donor's deduction, the parties are free to modify or terminate the easement as they see fit. And there are still others who argue that individual states or even coalitions of holders should be permitted to devise their own varied procedures for substantially modifying and terminating perpetual easements. It would, of course, raise significant efficacy as well as equity and valuation concerns if landowners claiming large federal deductions for the donation of perpetual easements could more easily lift those restrictions, escape them in some states than in others. It's also worth considering the long-term consequences of weakening the durability of this very special and uniquely powerful perpetual land protection tool. One thing most would agree on is the need for reasonable rules regarding the amendment of these perpetual instruments so they can adapt to changing circumstances over time while continuing to protect the integrity of the easements. But the uncertainty in the law regarding this fundamental issue, coupled with the inevitable pressures that will be brought to bear to develop protected lands, makes the widespread use of conservation easements a grand and hopeful but somewhat dangerous experiment. Which brings us back to why we are here this afternoon, to take stock, to consider where we are, what we've learned, and where we should go from here, with the dual goals of minimizing abuses and ensuring that these instruments will actually provide the promised conservation benefits to the public over the long term. Thank you.